Good morning, everyone. Let's continue with the state's case, Mr. Gravely.
The state calls Christine Remsburg to the stand. Or I just have not turned it on. I apologize.
Guilty as charged. All right. Good morning. Tell me, by the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Ms. Remsburg, you need to speak right into that microphone, okay?
I'm going to move the chair quick.
Okay, yep.
Okay.
Can you state your first and your last name, and please spell both your names for the record?
Christine Remsburg, CHRISTINE REMSBURG.
And Ms. Remsburg, how old are you today?
33.
I'm going to show you what's been marked as State's Exhibit 42. In the meantime, Ms. Remsburg, while this is being done, have you ever been convicted of a crime?
Yes.
And how many times?
3.
Ms. Remsburg, again, I'm going to show you what's been marked as, counsel's that, again, is it 42, Defense Exhibit 40, or is it State Exhibit 42? I'm going to show you what's been marked as State's Exhibit 42 up on the screen. Do you see that picture?
Yes.
And do you recognize that individual?
Yes.
What is that individual's name?
Zachariah Anderson.
Do you see what that person's wearing in terms of above the waist clothing?
Yes.
And how would you describe that outer garment?
His flannel coat.
Is that something that you recognize as a item regularly worn by Mr. Anderson?
Absolutely.
And is this an item that you ever came in possession of? In other words, after 2020, was this either left at your house or ever something you had?
A couple times, like when he would stay over, it could have been left at the house, but I never took it to him or anything like that, and I don't know where it is.
Have you moved from the house you lived at back in May of 2020?
Yes.
And was it at your house when you moved?
No.
So you do not believe it was left at your house after your relationship with Mr. Anderson was over? Okay. Is the person you've identified as Mr. Anderson, is he here in the courtroom today?
Yes. And
can you point out where that person's located and what they're wearing? What is the person wearing?
he's wearing his blue suit.
Can you give me a description of any other item?
His tie.
And what colors are the tie?
Blue and red.
I'd ask for the record to reflect the identification of the defendant.
She's indicating the defendant.
Ms. Remsburg, during the period of May 19th, 2020, were you over at the defendant's home in the evening hours?
Yes.
How did you come to be at his home on May 19th?
He invited me over for a movie night.
And how many times do you believe you had been to his house before that?
Around 3 times. Okay.
And on the 19th, when you were present, did you see something happen to Mr. Anderson? In other words, was he removed from his home?
Yes.
So what happened to the defendant?
He got arrested.
Okay. And how had you gotten to his home on the 19th of May?
I drove the 2009 Audi.
I'm going to show you what's been marked as State's Exhibit 1, Photo 271. It's going to go up on the screen. Just tell me if you recognize that item when it comes up. Do you recognize that?
Absolutely.
What is that?
The Audi.
And you drove that, and whose car was that in May of 2020?
Zachariah Anderson's.
Okay, so how did you come to be a person driving that over to his house on May 19th?
I didn't have a car due to a car accident I had, and I needed a way to get back and forth to work when I was able to go to work after COVID.
Prior to May of 2020, how much earlier than that, how many weeks or months or years before that, did the defendant give you his Audi to drive to be your normal transportation?
That was the first time.
For how long though?
4 to 6 weeks.
About 4 to 6 weeks
Yes.
from the date of his arrest?
Yes.
Okay. And during that period of time, did you have that car on an everyday basis because he had lent it to you?
Yes.
Okay. So what vehicle, if you know, did the defendant drive during that period of time?
His minivan.
So I'm going to show you what's been marked as State's Exhibit 1, picture 254, and ask you if you recognize that particular vehicle.
Yes.
What vehicle is that?
That's his minivan.
That's the minivan of the defendants?
Yes.
So while during that 4 to 6 week period you were driving the Audi, to your knowledge, what vehicle was the defendant driving on an everyday basis?
The minivan.
The one I've identified in this picture?
Yes.
How often were you in that minivan during the time period of April and May of 2020?
Not very often.
What sort of circumstances would cause you to be in the minivan?
It was probably before that, but just going to the grocery store.
I'm going to show you what's been marked as State's Exhibit 1, picture 263 for just a moment. If I told you that's the back of the same minivan, do you recognize the carpet being removed from that minivan? Did you ever see the van like that?
No.
On May 19th, 2020, when you were present at the defendant's house and he was arrested, what was the status of your relationship, if any, with the defendant?
We were dating.
And how long did you believe, or do you believe you had been dating the defendant prior to that time of May 19th, 2020? How long had this been going on?
About a year, give or take.
About a year?
Yep.
And how often were you seeing him, let's say per week during that year?
4 to 5 times a week.
And when you say you were, or when I say you were seeing him, when you say you saw him 4 or 5 nights a week, what did that mean? So in other words, what was going on?
He would come over shortly after I got done with work or whatever was going on with his day. We have a movie night, spend the night, and we take off to work and do our own thing in the morning.
Okay, so I want to be sure I have this right. May 19th, 2020, you're saying, give or take for about a year, the defendant's been coming to you, you guys have been spending the night together 4 or 5 nights a week. Is that accurate?
Accurate, yes.
How many of those nights did you spend at his house? Of those 4 or 5 nights a week, how often had you spent the night at his house?
It was always my apartment.
Okay. When's the first night, if ever, that you spent a night at his house?
I never spent the night over at his house.
Was the plan that you were going to spend the night on May 19th?
I don't know if that was the plan. It was just being invited over for a movie night. But yeah, at the time, yes, I would.
You believe so? Okay. Where were you working during that period of time?
Libby, Montana's.
Now, on so that was a Tuesday, May 19th, that he was arrested. When the defendant was arrested, did law enforcement then also speak to you?
Yes, the same night he was arrested.
Okay. And did they want to know about the previous Sunday? So 2 days earlier, 2 nights earlier.
Yes.
They were kind of focused on that, weren't they?
Yes.
And what did you originally tell them that you believed was the whereabouts of the defendant on the evening of May 17th, which would be that Sunday? What did you originally tell him?
What I originally told him is that he was over, but like I told him when they look on my phone, it says on my way, he was over. If it doesn't, he wasn't there that day.
So originally you said you thought he was over there.
Yes, originally that's what I said, yes.
And did you tell him you thought he came over around 6 o'clock after you got off work? Is that what you told him originally?
Yeah,
Did you tell him, and then he never left the house? Did you tell him that's what you originally thought?
yeah,
And did you say he stayed until about 11 a.m.? Is that what you originally told him?
yes,
Okay. Now, did you also mention to him that there was another person who might be even a better source on whether he was at your house or not that night? Did you give him another name of somebody who might know even more or be more sure?
what do you mean by that?
Well, did you mention that your sister might be somebody who would even know more information or be more sure about it?
Yes,
Okay. And ultimately, did the officers come back to you
yes,
and re-question you about the 17th? In other words, what had happened 2 days earlier?
yes,
Okay. And when they did that, did you decide that, in fact, he had not been at your house on the 17th?
yes.
Okay. And is one of the things that happened is that you went through your phone, or that there was phone evidence where you could tell that he had not come over?
I'm going to object as far as leading.
And
At some point, did you share phone evidence with law enforcement?
Yes,
Okay. I'm going to show you what's been marked as State's Exhibit 164.
that. Sorry, I don't have my glasses.
Is this hard for you to see?
Yeah.
Okay. So if, Ms. Remsburg, if you have to get closer to be able to see it, please let us know, okay? That'll be okay. We'll have you hold a microphone. Judge, do you still have that microphone up there if she needs
I
it?
do. Oh, that's right there.
Oh, sorry.
Have to be turned on. May I have it, please?
Oh.
Well, you're younger than me. You probably can turn it on. First try. Very good.
So, and I'm going to approach just close enough so I can see. Okay. So, did you receive a text from Zachariah Anderson's phone to you on your phone at 4:57 p.m. on Sunday, the 17th of May, where he says cool?
Yeah.
Okay. And then at 6:35 p.m., do you text the defendant's phone and suggest to him you got a movie in mind?
Yes.
And so does that text, is that a text you sent him?
Yes.
Okay. And with that, so you don't have to read it. Does the text, is that all right if I just read it as opposed to making her read it?
Fine.
Okay. Does the text at 6:35 p.m. to the defendant say from you, Alice in Wonderland, Land 1933, gotta find it and watch it, it's my new mission M. Do you see that?
Yes.
Okay, that's a movie that you're discussing?
Yes.
And are you expecting the defendant at that time to still show up at your house?
Possibly, yes.
Okay. I mean, you had plans with him, did you
Yes.
not?
Yes.
Okay, and so you are suggesting for our movie night, here's what I'm thinking. Yes?
Yes.
Okay. Any response from him at that time?
No.
Okay. Now I'm at 9:20 p.m. Up to then, have you received any texts from him or calls from him since you told him, hey, the movie's Alice in Wonderland? Has there been any, has he been in touch with you in any way?
No.
Okay. So now at 9:20 p.m., you text him and you say, get to keep kiddos tonight? Is that true? Did you text that?
Yes.
And you're at 9:20 p.m., right? When you send that, 9:20 p.m.? Okay. Still no response until the next time you text at 10:31?
Correct.
Okay, at 10:31 p.m. or 10:31:09, do you text the defendant, whatever, going to bed?
Yes.
Okay. It's fair to say you're not happy at that point?
Yes.
Okay. And is the first time you hear from the defendant a text from him that says, fell asleep, sorry, missed afternoon nap? Is that what he said?
Yes.
Okay. And then after that, did you receive a call
I'm
from
going to
him?
object to leading again.
It's sustained.
What, if anything, can you say about later whether you got a call from him?
Yes, I don't remember the whole phone conversation, what it was about, but usually we just talk about our day or how we feel and what's going on.
All right. And did he ever arrive at your home that night?
That night, no.
Okay. Then the next day, did you have an opportunity to be in texting conversation with the defendant again?
Hold on.
Yeah. Is the mic still working? You can speak into the normal mic.
Okay.
Yeah.
What was the question again?
Yeah. On the next day, so Monday morning, were you again texting back and forth with the defendant?
Yes.
Okay. And so I'll ask you if you recognize this text. Can you read that text? It's going to be a long day. Still haven't got to work. Hit you up later.
I'm going to object at this point. I'm going to ask that he ask a question and she responds.
Okay. Well, I'm reading the text. These are stipulated records. I'm reading them and asking him, is he familiar with them?
I'm not sure if you're suggesting that this is becoming a narrative or if you're objecting to this as being leading or something.
Well, one, it's leading. Two, it is a narrative if he's just going to be reading things and at her. And not sure what the relevancy is of reading every single text message between them. So if there's a question about a particular text that he has, then I would ask that he ask that question.
Well, I think he can make his presentation. The objection is overruled.
Okay, so again, I'm going to read it just for purposes of you not having to approach. I'm going to read you the content of the text again.
Okay.
It's going to be a long day. Still haven't got to work. Hit you up later, babe. Is that a text you received from the defendant's phone on a time period that is noted as 8:54 a.m.? Is that a time you received that text?
Yes.
Okay. So when the defendant texted you and said, I've had a nap, and so that's why I haven't answered any of your texts, you don't know for sure if he had a nap.
Objection leading.
Well, this particular question I don't think is suggestive of a particular answer.
I think it is, because I think the proper question, Judge, would be when you received that text, did you know exactly what Mr. Anderson was doing?
Well, that would be a better version. I'll grant you that. But it's I don't think it's one where there's particular concern about coaxing the witness into a particular answer. So the objection's overruled.
Did you know one way or another whether he was taking a nap when he texted you or had been?
How could I? I was at home.
Okay. And when you received the 8:52 text indicating that the defendant had not yet arrived at work, you had no idea where he was, did you?
Absolutely not.
Anything else on those? Thanks. You can take those off. that Monday, when, after the text that said, I'm not at work yet, do you recall when the first time you saw the defendant was on the 18th? Like, what time did you first meet up with him in any place? Your place, his place on the 18th?
Was that Tuesday?
It was a Monday?
Tuesday.
So, what?
Was it Tuesday?
It was a Monday. Only if you know.
I don't remember. I just know on Tuesday is the movie night and I was over there around 7.
Do you remember telling law enforcement that on May 18th, you went to his home about 6 p.m.? So that would be the Monday that you also went
Oh,
to.
I'm just confusing dates. Okay.
Did you do that on
was Monday.
On Monday?
Yes.
But were you also there on Tuesday, the day he was arrested?
Yes.
Okay. On the 18th, when you went over to his house, so that's that Monday, did you have the Audi that day as well?
Yes.
Questions?
Cross-examine.
Thank you. Good morning, Ms. Remsburg.
Hi.
So I want to go back a little bit. The state had been talking to you about the first statement you gave law enforcement on the 19th, and then the second time you talked to them 2 days later. You had told law enforcement on the 19th that you had memory problems, and that's why it would probably be better to ask your sister, right?
I didn't specifically say that I have memory problems. No, but considering me and my sister lived together and I was going back to work and I do have shit drinks. So no, I'm not good at remembering dates, but knowing my routine. And that was what I told the authorities.
So, but when you told them that, it was because you weren't 100% sure.
Yes.
Okay.
Because usually he was over there. The only time that he wasn't over there, either we were working or he was with his kids.
And so then on the 21st, which was 2 days after you first spoke with law enforcement, you told them after seeing more information that he was not at the house on the 17th, correct?
Correct. And when I got asked and I thought he was there, I even had them look at my phone. So for them to say that I lied or I was covering up and harass me about it is not right. It's not okay.
Because you weren't covering anything up, correct?
No, I was just going by memory. I got hit that my boyfriend's in some kind of trouble. I asked the captain what's going on and he couldn't even tell me. I didn't know until later on at all, nothing. And everybody feels like they're attacking me from authorities from this way and this is going on. No one really cares about what I go through. I didn't want to come back here because of the harassment I've been through. And I'm here.
And it's because law enforcement never really wanted to hear your story, right?
Exactly.
You felt like they were pressuring you into what they wanted you to say.
I just felt they were thinking I was hiding something, pulling something when there was nothing there to pull.
Because when you were with Mr. Anderson on those days and talked to him, there was nothing suspicious, right?
Objection. Objection. Calls for hearsay.
The objection, well, it's leading.
This is cross-examination,
Right.
so I can lead.
Yes, you can. Yeah. That was in first year of law school.
Yeah.
That was a long time ago. Yes, you're correct about that. Well, the objection's overruled.
Do you want me to re-ask the question? I just said that during the times from May 17th to May 19th, 2020, when you either saw or were talking to Mr. Anderson, there was nothing suspicious.
That's an argumentative question based on my new understanding of what argumentative objections are in this courtroom.
I'll rephrase it.
That's to make a conclusion, and it's an argument.
The objection is sustained.
When you spoke with Mr. Anderson on May 17th, 2019, correct?
Yes, I believe so.
And the text messages before that the state had read to you about Mr. Anderson taking a nap, you remember receiving that text?
Yes.
And you said you had been dating Mr. Anderson for about a year?
Yes.
And during that year, I'm assuming you've known Mr. Anderson to sleep.
Yes.
And were there times where he would also nap?
Yes.
So receiving a text that he was napping, that wasn't anything out of the ordinary from your experience.
No.
And it's true too that during your entire relationship, there were times where perhaps you had planned on meeting up, but then that didn't happen because something else came up.
Yes.
Like sometimes Mr. Anderson would have his kids.
Yes, the schedule would change with the kids often.
And sometimes he would be tired from work.
Absolutely.
So it wasn't bizarre that he wasn't able to come over that evening.
Judge, again, this is propensity evidence, and it's an argument.
It's actually a follow-up of the state's questioning of her.
Objections overruled.
You can answer that question if you remember.
Could you repeat it?
Yeah, of course. I said that there was nothing bizarre then on the 17th about him not coming over because he had fallen asleep.
No, it's not bizarre, no.
And when you talked to him, there was nothing out of the ordinary about the conversations that you had with him that evening, correct?
It calls for hearsay. It's the words "talk to him" are in it.
I'm not asking what he said.
The objections overruled.
It's a characterization of a conversation. Apologize, Judge, but I do think
It's a characterization, but it's not. It is not seeking what is asserted in the conversation to prove the truth of it.
would have to be based on things that this defense attorney are not allowed to bring up. So it is hearsay. If you say, I don't want you to say what was said, but I want you to tell me whether the conclusion was X, Y, or Z from it. And the whole basis of it is verbal or is something that was said, that's hearsay. The defense is not allowed to bring that up.
I agree with that, but I don't think that what is being asked here is demonstrative of that.
The question began with based on what he said, and then the question was draw a conclusion based on what he said. What he said is hearsay from that side of the
objectionable part is not whether the witness drew a conclusion. It's if you offer either the conclusion or the underlying statement to prove the truth of the matter asserted, which would make it hearsay. I'm not going to argue about it anymore.
Okay.
Overall.
Thanks.
Was there anything suspicious about that phone call?
Can you repeat your question? Sorry.
Sure. I'll repeat it in full. The phone call that you had with Mr. Anderson the evening of May 17th, 2020, there was nothing suspicious about that phone call, correct?
No. I would have remembered something otherwise. To me, it was just a normal phone call. I don't remember exactly what we talked about even then. It's usually around the same thing. It was nothing I need to put on the schedule, so why would I?
And then you spoke with him, and then the next morning he texted you that you texted him, and then he texted you back that he was heading to work, right?
Yes.
And was that normal from your observations of Mr. Anderson that he would go to work in the mornings?
Yes.
And you were aware that Mr. Anderson was doing construction contracting work at a home up in Belgium, Wisconsin.
Yes.
And your understanding, where was Mr. Anderson going to work on that morning when he texted you?
I'm not really sure because the boys always did side work and that's the boys' thing, you know.
But you knew that he was working at that home around this time?
I don't know if it was that day, but I knew they were working on that project. Yes.
Okay. While you dated Mr. Anderson for the year, did you know him to have any sort of injuries?
Like what type of allergies are you talking about?
Like any sort of things that would prohibit him from moving around freely, any back problems, leg problems, anything of that sort?
He has back problems.
Okay, can you explain what you know of those back problems?
Sometimes he just can't move. He either has to lay there or he has to stand up and just keep doing stuff. It's serious pain enough to where you hold your back and you can't move.
Okay, and did you ever see him when he would have these moments of back pain?
Yes.
Objection irrelevant. Whether she's seen other moments unrelated to this time period is relevant.
Overruled.
And how frequent did this happen?
Same objection.
Overruled.
How frequently did Mr. Anderson experience back pain and issues?
It was daily. Sometimes it was worse. Sometimes some days were better.
And do you remember if there was anything that would cause him to have back pain?
Heavy lifting that he would end up doing.
Okay. And to your knowledge, was it hard for Mr. Anderson to do heavy lifting because of his back issues?
Yes.
So you had gone over to Mr. Anderson's house from May 18th and on May 18th and May 19th?
May 18th and May 19th, you said?
Yeah.
Yes.
And when you were there, Mr. Anderson, was he with you?
Yes.
And you never saw Mr. Anderson with bloody clothes, correct?
No.
And did you ever see him getting rid of what appeared to be some sort of evidence?
No.
Was it just a normal weekend and day for you? Like how he was acting and what you guys were doing?
When
Objection. Council Monday would be the 8th. Would it be a Monday? 18th and 19th.
Okay, I apologize. Sometimes us
Sorry,
lawyers get our days mixed up too. When you were together on Monday and Tuesday, what were you guys doing?
That's what we normally do. We sit around and talk and just enjoy each other's time. We eat. I would cook breakfast.
Okay, so there's nothing out of the
Nothing out of the ordinary at all.
Okay. And on the 19th, so that would have been the Tuesday when you were there, the day Mr. Anderson got arrested, Do you remember people coming to the house?
I sat in the living room. He told me there was pastor, so I sat in the living room, acted like I was playing a game on my phone. I knew he was on the phone as either his dad or his brother. And then he called the police, and we went to meet the police in the driveway. I remember that day like it was yesterday.
Okay. Why don't you talk a little bit more about what you remember?
Again, the objection is that it's not a specific enough question because it potentially calls for hearsay in its general form. So I'd ask that it be more specific simply to prevent hearsay from being presented. Because what the defendant told her would be hearsay. So,
If I may respond, the first question I asked her was May 19th, what do you remember about two people coming over? And she said she remembers that day vividly. So then I just asked her, well, what do you remember about that day? That's a fair enough question.
so she's already, I apologize, finish. Didn't mean to interrupt you.
I didn't ask about what any statements were said by Mr. Anderson. I'm simply asking her what her recollection was of May 19th, 2020.
And
All right, yeah, go ahead.
her answer to the initial question was what included a couple things that he told her. Okay, so to ask the general question again, to have her be more detailed about the general question, does not preclude the hearsay.
And
I'm just hold on just a minute, Counsel. I'm just trying to make sure we're a steward of not presenting evidence that's not permitted. So if I was a lay witness and I heard and I just reported, here's what happened, here's what somebody said, and then I was asked, can you tell me more about that? I would, of course, go back and report those things again. The first question did not call for that, but the answer included it. And so now, from the state's perspective, to be a good steward and try not to present hearsay evidence, we simply have to ask that the question be more structured.
in order for hearsay to be hearsay, it has to be a statement that's used for the truth of the matter asserted. Anything that, if I may, Judge, thank you. Anything that Mr. Anderson told her about sitting down and then her going in and sitting down would be an effect on the listener exception. I'm not looking to seek any of that into evidence, nor do I think that's what's been elicited here.
It's my interpretation, he is making a precautionary objection to prevent hearsay from seeping into the record. You've inquired about the event, and there was reference in the witness's answer to conversational matters, and that is an area of high risk that the witness will stray into something that would be hearsay. He hasn't claimed that there's been hearsay. I think what he's asking for is more like abandonment of the
Sure.
of the narrative type answer and ask specific questions
Sure.
so as to reduce the risk of hearsay.
Sure.
So there's nothing for me to sustain or overrule other than I think it would be prudent. And let's try that route.
So I just want you to talk about what you personally saw. Does that make sense? Not anything that Mr. Anderson would have told you.
Yes.
So in what you personally saw, did you see the people who were trespassing on Mr. Anderson's property?
No, because why would I step out of the house in danger where there's trespassers? When there's a man there calling the cops, the woman should stay in the house and be protected.
And did you feel protected by
Yes.
Mr. Anderson? And in your whole year of dating Mr. Anderson, did you always feel protected by him?
Yes.
Your relationship with Mr. Anderson, it was relatively serious, right?
Yes.
You guys had very strong feelings for each other.
Yes.
Did you ever feel like Mr. Anderson was not trying to date you?
No.
And were you aware of of who Mr. Anderson's children's mother is?
I didn't know what she looked like, but yes, I knew her name and I respected their relationship and him doing his best to be a single dad.
Okay. I have no further questions, subject to recross.
Ms. Remsburg, you were asked a question about whether there was any reason for you to believe that you were not in a serious relationship with strong feelings for each other. What, if anything, can you tell us about whether you were aware of any texts or meetings or efforts by the defendant to get back together from January of 2020 through May of 2020 with his ex? Were you aware that he was making
He
efforts?
did have a dinner with her and he did tell me about it, about where the relationship fell apart, if it's better to get back together. He knew I was willing to let him go, but he showed me that's not what he wanted.
So he was telling you, I don't want to get back together with her during that period of time. That's what you were hearing?
Yes.
Okay. And you indicated that the defendant sometimes had back problems, but you also knew he worked as a contractor, right?
Yes. Well, any man that's older, everyone's got backgrounds, but he has some severe backgrounds where he would have really bad days like you. Do you have really bad days and really good days with your back?
I, in fact, do. Yes.
Yeah.
So there were good days as well.
Yeah.
Okay. And then sometimes when heavy lifting happened, you are aware that the defendant would have to call and get some assistance for that. If he did some heavy lifting, he would need to get.
I wouldn't be aware because I wasn't at work with them.
Oh, okay. I apologize. I thought you said that you knew that then he sometimes got help for it if he had heavy lifting.
No, I wouldn't know because I wouldn't be working with them.
Got it. But sometimes after heavy lifting is when he appeared to have that back problem.
Yeah, of course, when someone you're seeing comes over, you can tell when they've been in pain because they hurt their back from work or something that day.
Okay. So you indicated that on the 18th and 19th, nothing seemed out of the ordinary to you. When you saw him on that Monday and Tuesday, nothing seemed different.
Nothing to send any red flags, no.
Okay. So now I want to turn your attention back to a time period around April 24th. So just a few weeks earlier.
Okay.
During that time period, were you also have overnight with him 4 or 5 nights a week?
Yes.
Okay. And did you notice anything out of the ordinary during that period of time?
No.
And now I'm going to turn your attention to May 8th. And on May 8th, right after, in that week or time period right after May 8th, were you seeing him 4 or 5 nights a week?
Yes.
And was there anything out of the ordinary in his conduct or how he acted towards you or anything during that period of time?
No.
What about May 13th? Immediately after May 13th, did you have anything that happened that seemed out of the ordinary in your mind?
No.
So you indicated you had heard and knew that the defendant worked as a contractor. Were you aware that he was also making money in the growing and sale of marijuana?
I'm going to object. It's argumentative and non-relevant to this case, Judge.
So I want to make an argument.
I'd like this to be heard outside the presence of the jury.
I guess it's time for you to leave us alone. How about a little break? Don't talk about the case during the break. Read, watch, or listen to any account of the trial. I'm going to say let's say 20 minutes. 20 minutes. I'm told one of the jurors threatened to bring a stopwatch. Yeah. Upstairs. Thank you.
Should she leave the stand for the
You
period of
can.
time? Okay.
Yeah.
continue, and I think Mr. Gridley will go first.
Sure. But the question I asked was whether Ms. Remsburg has knowledge of a significant marijuana grow operation taking place at the defendant's home that she's at those 2 days.
Right.
So from the state's perspective, this only becomes relevant under a line of questioning where Christine Remsburg is asked, during this relationship, or have you noticed anything suspicious during these time periods? Is there anything that was out of the ordinary or something that you believe is suspicious? So at this point, a very valid argument from the defense would be Ms. Remsburg, who's in a long-term relationship with him, knows him well, spends 4 or 5 nights a week with him, is a purported witness that based on what she knows about him, that there is nothing alarming or suspicious in his conduct that she is observing of. So her quality as an observer certainly now is an issue. And here's my offer of proof to the court so the court knows where I'm at. She accompanied the defendant to a court hearing on a South Dakota drug case that the defendant had pending during this case. It's a
Judge, sorry to interrupt. No, this is not, it's more of a technical thing. Just because we might be discussing other witnesses' testimony, things of that sort. Ms. Remsburg's in the courtroom. I would just ask for purposes of this discussion that she not be present due to the exclusion order.
We've been doing it.
Okay.
We've been following.
Okay.
Yes, we